The government possessed soundless video recordings of attorney visitation rooms at CCA and possessed and distributed audio recordings of telephone calls between several detainees and their legal counsel. Moreover, the court easily finds that the government willfully violated myriad court orders and special master directives, and the court imposes monetary sanctions for these violations. The government's credibility is now directly at issue.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So we're going to find out today why the Kansas U.S. Attorney's Office, the entire office, is in contempt of court. This is 188 pages long, and we will not be going over all of it. We're just going to go over the introduction, and then I'm going to leave you hanging. The Sixth Amendment guarantees an accused the right to assistance of counsel for his or her defense. This right is indispensable to the fair administration of our adversarial system of criminal justice. It safeguards the other rights deemed essential for the fair prosecution of a criminal proceeding. The Sixth Amendment right to effective assistance of counsel includes the ability to speak candidly and confidentially with counsel free from unreasonable government interference. For the adversary system to function properly, any such advice must be shielded from exposure to the government. That bedrock principle is at issue in this case. The government initiated a drug conspiracy investigation in the spring of 2016 targeting the detainees and employees of Corrections Corporation of America, a large private detention facility located in Leavenworth, Kansas. So is that like the Leavenworth? Right? Like there's only one Leavenworth prison, right? Like that's the Leavenworth. Although the case initially charged 6 defendants with various drug offenses, the government suspected the conspiracy involved at least 95 inmates and 60 more individuals outside the facility. Private prisons, am I right? Facts uncovered after an early discovery conference in this case revealed discovery practices that implicated the Sixth Amendment right to counsel. The government possessed soundless video recordings of attorney visitation rooms at CCA and possessed and distributed audio recordings of telephone calls between several detainees and their legal counsel. In case you'd missed that, the government spread video recordings without audio of attorney visitations and audio recordings of telephone calls between detainees and counsel. Oh, even the video could be, because you could figure out what they're talking about or maybe read lips or something. The court immediately clawed back and impounded the recordings and conducted several emergency hearings on these issues, prompted in part by the involvement of the Office of the Federal Public Defenders, which was allowed to intervene in this case on behalf of its many clients detained at CCA. At these early hearings, the court endeavored to find out from the government the scope of its discovery efforts that potentially intruded on confidential, in-person, and telephonic attorney-client meetings, but the government evaded the court's questions and denied that its practices implicated the Sixth Amendment or attorney-client privilege. The court ultimately appointed Special Master David Cohen to investigate. The government did not cooperate with his investigation, and its failure to cooperate ultimately resulted in a lengthy delay in this court's ability to rule on these issues. Finally, despite the delay associated with the government's failure to cooperate and its litigation efforts challenging the propriety of the Special Master's investigation, the court concluded a full evidentiary hearing on all pending matters in this case in October-November of 2018. The court is now prepared to rule. Under extant or extensive 10th Circuit law, the purposeful intrusion by the government into the attorney-client relationship, absent a countervailing state interest, constitutes a per se or automatic violation of the Sixth Amendment, with no need to demonstrate that the defendant has suffered as a result. The Supreme Court requires the remedy for a Sixth Amendment violation to be tailored to the injury suffered and not unnecessarily infringe on the competing interests of the fundamental right to assistance of counsel and respecting society's interests in the administration of criminal justice. In this case, the court's attorney-client privilege and Sixth Amendment analysis is necessitated by the FPD's motions under Rule 41 for return of property. As part of the Sixth Amendment analysis, the court must necessarily evaluate the government's lack of meaningful cooperation in the Special Master's investigation because the government's credibility is now directly at issue. The purpose of the Special Master's investigation was to work with all parties and with Securus Technologies, the company that provides for telephone recording equipment, to determine the extent of the attorney-client communications that were obtained and or accessed by the government. Because the government did not abide by this court and the Special Master's preservation and cooperation directives, preservation means they didn't preserve evidence, this opinion discusses evidence of these failures and considers a remedy. Although the court declines to impose spoliation sanctions, yes, that's a real word. It kind of means spoiling evidence, so you can kind of switch the L and the I there, but it is spoliation is the word. Spoliation sanctions, or you've let the evidence expire, or you've let the evidence, you've lost the evidence, or you've willfully destroyed the evidence. That's spoliation. Sanctions would be for the spoliation. Sanctions or punishment at this time for the government's probable destruction of evidence material to the Special Master's investigation. The record in this case may lay the groundwork for specific spoliation claims in individual cases brought under Section 2255 of Title 28 of the United States Code. Moreover, the court easily finds that the government willfully violated myriad court orders and special master directives, and the court imposes monetary sanctions for these violations. The court's findings of fact shine daylight on the government's practice of obtaining attorney-client communications and its view that these communications are not protected and thus not subject to scrutiny. While the Sixth Amendment requires particularized findings to determine whether an improper intrusion into the confidential relationship with counsel occurred, and if so, the appropriate remedy, this record allows the court to consider several legal issues that implicate the Sixth Amendment analysis and are common to all affected litigants. These issues include, among other things, the elements required to prove a per se violation of the Sixth Amendment under Tenth Circuit law, whether soundless video recordings constitute protected attorney-client communications, whether the preamble language that played at the beginning of Securus telephone calls constituted a waiver of a attorney-client privilege, and whether the government had a legitimate law enforcement purpose when it procured the recordings at issue in this case. In the end, this case presents an opportunity to provide a wide lens view of the government's conduct implicating the Sixth Amendment inquiry. The culture of the Office of the United States Attorney, particularly in Kansas City, Kansas, directly bears on that analysis, and the USAO's pattern of similar misconduct in other cases is relevant to the court's determination of witness credibility on the issue of access to the recordings and of the appropriate remedy for detainees prejudiced by an intentional intrusion into their attorney-client relationship. Likewise, the USAO's delay and obfuscation in the Special Master's investigation will weigh into fashioning an appropriate remedy in the 2255 cases. Litigants have been unable to seek or obtain relief in their individual cases or on direct appeal because the evidence necessary to support their claims is either still impounded by this court or because the Special Master's investigation was impeded by the government's machinations. Audio recordings of attorney-client calls obtained by the USAO continue to be produced in August 2019, almost 3 years after the investigation began. Evidence likely has been lost due to the government's failure to timely implement a meaningful litigation hold, and the government's productions to the Special Master and FPD were incomplete and turned over in a manner designed to mask the individual source of production. So they've even seemed to have taken willful steps to prevent the unmasking of the source of the production. The government's wholesale strategy to delay, diffuse, and deflect succeeded in denying the individual litigants their day in court for almost 3 years. The strategy continues today and can be found in the government's proposed findings of fact and conclusions of law, where it contends that most detainees' communications with their attorneys are not protected and that the USAO was correct in unilaterally determining that it had the right to access such information. It can also be found in the government's responses to the pending 2255 motions, where it contends that these claims do not deserve to be considered on the merits. The day has come to bring this case to a final decision. This opinion is intended to provide a roadmap for future consideration of the many cases pending on the issues under 2255. It orders a release of the video recordings to the FPD, which has been appointed by standing order to represent any litigant alleging claims based on the facts surrounding the Special Master's investigation. It will continue the habeas cases under one United States magistrate judge for discovery and reassign them to the undersigned for a consistent application of the principles set forth in this opinion. It will make clear the common legal standard that will govern in these proceedings and what must remain pending for particularized findings in each case, which means that there's setting a roadmap for how cases will be handled in the future, and this is not necessarily the document that handles all those cases. And then this is how they're going to formulate the next 180 pages, which we're not going over, but we are going to skim through and try to find how much money or what the punishment was to the U.S. Attorney's Office. This opinion begins by setting forth a summary of the complicated and lengthy procedural background in this case, which proceeded in generally 3 parts and explains the scope of the court's opinion. Next, the court sets forth its findings of fact on the government's cooperation with the Special Master's investigation and compliance with the court's orders related thereto, followed by the court's findings of fact on the merits. Finally, the court provides conclusions of law on the FPD's requests for sanctions against the government and then on the merits of the Sixth Amendment claim. The court concludes by providing a roadmap for managing pending litigation. Let's see how long that is. I'm going to go back up to the table of contents here. The conclusions here. So here it's going to be 20 pages on sanctions, but it starts on page 123, and that should be what we want to look at, and then 179 to the conclusion. So let's go to page 123. The FPD's motion to show cause asks the court to require the government to show cause why it should not be held in contempt for failing to cooperate with the Special Master's investigation, including spoliation of evidence, defiance of court orders, including orders directing the USAO to preserve evidence, delay in providing statements by key USAO employees to the Special Master, failure to act with candor and transparency with the court and the Special Master. By the way, you may not know that lawyers have a duty of honesty and candor to any tribunal that we represent a client in front of. So it doesn't mean that we have to give them any information that, we don't not required to provide by a court order or by a law or something. But it does mean that if we're going to provide information, or if we're ordered to provide information, it has to be given with candor and honesty and not shenaniganery. Recalcitrance in failing to timely correct the record in black with the information about Tomasic's conduct in United States v. Herrera Zamora. So there would have been either case law or evidence that based on case law would be operative in this case, and the lawyers do have a duty to inform a court if they become aware of operative case law that tends to negate or affirm something in the case. And changing course in September 2017 when Clymer, I guess it's Attorney Clymer, was appointed in this matter by asserting that privilege justified the government withholding information it had previously agreed to provide the Special Master. The FPD also seeks fees and costs for contempt and for unreasonable and vexatious multiplying of the proceedings under law, 28 U.S.C. 1927. The government disagrees. There was a lot. The court appointed a Special Master to investigate. They apparently did not cooperate. The destruction or significant alteration of evidence or the failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation is spoliation or destruction of evidence. Spoliation sanctions are appropriate where there is a duty to preserve and the adverse party was prejudiced by the destruction of evidence. As described in the court's findings, the AVPC was the only computer on which the USAO staff could view the video recordings obtained from CCA. With the exceptions of Boyd and Stokes, all government witnesses denied watching the videos. Boyd testified that although she drafted a cheat sheet to help attorneys operate the Pelco player on the AVPC, the attorneys required her to load and view the videos, and no other attorneys asked for her assistance. This testimony is corroborated by other testimony that she needed to coordinate with Boyd's schedule in order to find a time to watch the video of her meeting with a defendant on August 5th, 2016. It's also cooperated by the court's experience, etc. So they definitely failed to preserve the hard drives that contained video evidence. The testimony was that a forensic expert would charge $5,000 to $10,000 to search for missing data on a computer system. As already explained, the government had a duty to preserve the evidence surrounding their practice of obtaining audio and video recordings of meetings between federal detainees and their attorneys as of early August 2016. The court can easily find that the USAO did not take reasonable steps to preserve at the time the duty arose. Generally, when a company or organization has a document retention or destruction policy, it is obligated to suspend that policy and implement a litigation hold to ensure the preservation of relevant documents once the preservation duty has been triggered. It is not enough to simply put in place a litigation hold to ensure preservation. The litigant must also oversee compliance with the hold. As the court noted in its findings, the government's misrepresentations, delays, and lack of transparency about the state of its preservation efforts in this matter make it impossible to conclude with certainty what information has been lost and cannot be restored. To November 6, 2018, there is no clear record that a central litigation hold was in place, which means that ordinary retention policies applied to electronically stored information prior to that date. In the email context, that means that any email from before January 1st, 2016 may have been deleted. The court concludes that the government acted with intent to deprive the special master and FPD of evidence in this investigation. The court found that the USAO willfully misconstrued the court's early preservation orders to avoid impounding and preserving evidence outside of the discovery and defendants at issues in the Black case. Despite several prosecutors' recognition that the court's orders went beyond evidence in the underlying Black case, USAO management decided not to seek clarification from the court and proceeded with a narrow construction of the orders. The court also found that the USAO purposely delayed issuing a formal litigation hold until May 2017 and withheld all information about the formal litigation hold from the special master and the court until the November 2018 hearing in this matter. There is evidence that Metzger, as the litigation hold coordinator, made these decisions with full knowledge that she was losing some stuff in the interim. To the extent a litigant can show that information relevant to his or her case was lost during the course of these various litigation hold delays and cannot be restored, this record supports an argument that Federal Rule of Civil Procedure 37E2 should be invoked, triggering sanctions that may include adverse inferences. An adverse inference is when the judge assumes that what the motioning party, the person asking for the inference, that what they're saying is true. So if the accusation is that the U.S. Attorney's Office improperly recorded and listened to privileged conversations, attorney-client privileged conversations, if that's the accusation, then that accusation will be assumed to be true if they can't produce evidence that does exist and show otherwise. So if the U.S. Attorney's Office is saying, no, these recordings are all waived, there's no attorney-client privilege here because there's a recording at the beginning that says, your phone call is being recorded and you do not have attorney-client privilege, do not talk to your attorney on this line. If it says that and everybody talked to their attorney anyway, well, great. Problem solved. Just play the recordings. Show us these recordings that you were supposed to preserve. Oh, you can't. Well, maybe we don't believe you now because you were the one who was supposed to preserve the recording. You said you had the recording and now all of a sudden you don't have the recording. We can assume that the recording says what the opposing party says it says, that there was no waiver and that it was a violation of attorney-client privilege to record and listen to the call. All right, so they've sought sanctions. Civil contempt sanctions may include dismissal or contempt, which includes anything appropriate to compel future compliance with an order or to compensate an opposing party for failure to comply. Both criminal and civil subpoena rules provide that civil contempt may be the remedy for a witness who disobeys a subpoena without just cause. To prove civil contempt, the FPD must show by clear and convincing evidence that a valid court order existed, that the government had knowledge of the order, and that the government disobeyed the order. Additionally, the court has inherent authority to fashion an appropriate sanction for conduct which abuses the judicial process. Because of their very potency, inherent powers must be exercised with restraint and discretion. Although the court's discretion includes the ability to dismiss as a sanction for severe cases of misconduct, the lesser sanction of attorney's fees against counsel may be imposed for actions taken in bad faith, vexatiously, wantonly, or for oppressive reasons. An award of attorney's fees is permissible if the moving party shows bad faith by delaying or disrupting the litigation or by hampering enforcement of a court order. The court discusses below the various ways the government knowingly violated the court and special master's orders. Then it discusses the appropriate sanction. Okay, we're going to skip how they didn't preserve evidence because we've kind of covered that a little bit. And if you really want the details, it starts on page 138 of this order, of this opinion. So there's going to be some kind of compensatory award, either as a remedy for contempt or for abuse of judicial process. To impose a sanction of fees and costs under the court's inherent authority, there must be a but-for causal link between the litigant's bad conduct and the legal fees incurred. The FPD's motion for fees and costs focuses on different conduct, namely, it identifies fees and costs associated with the failed settlement negotiated in the summer of 2018. Although the court is cognizant of the needless delay associated with the fruitless settlement attempt last year, its findings in this order do not address violations tied to that conduct. Because the FPD did not address the causation showing required for misconduct tied to the government's preservation and production obligations, the court cannot determine from this record the scope of any fees and costs that should be awarded. Instead, under its inherent authority, the court will award fees and costs borne by the FPD in line with the causation requirements of the Hager case. Because this issue was not fully briefed by the parties, the court directs the FPD to submit an application for attorney's fees and costs, addressing both its entitlement to fees and costs and the amount by September 24th, 2019. The government may respond by October 15th. A little bit anticlimactic, but that's where we'll leave you hanging. We will find out how much money the U.S. Attorney's Office will have to pay. And here's the thing, the word up here, where was it, was that they might be able to bring the motion or the sanctions against them individually. So it might be that the attorneys themselves and not the government, but the attorneys themselves might be personally responsible for the amount of the sanctions. That's highly likely here because they are officers of the court and are basically held personally responsible for not acting in accordance with their rules, procedures, model rules of professional conduct, state rules of professional conduct, courts rules and order. This is all very complicated, and so you could certainly understand how an attorney could make a mistake. This went far beyond a mistake. This was an intentional act and a doubling down. When the court disagreed that the attorney-client privilege had not been violated, when the court disagreed and thought that it had been violated, the U.S. Attorney's Office didn't take steps to, say, preserve evidence for future litigation, and instead started to cover their tracks. And that's worse. That's way worse than just having disagreed on whether you can record attorney-client privilege communications or not.
Yeah, the appropriate response would have been to appeal, not to destroy evidence.
Yes.
So police officers can get qualified immunity if they are operating within sort of their, under the umbrella of like what's reasonable for a police officer to do. Do non-police officers get qualified immunity? Like if you're acting on behalf of the state?
The U.S. Attorney's Office, the attorneys might have some kind of, it might not be called qualified immunity. It's probably called some sort of litigation privilege or litigation immunity. The attorneys can't be held personally responsible for the actions of the people they represent, or in this case, the government that they represent. However, if it's the attorney's individual actions that cause an injury or something, yeah, maybe no longer does that apply. So it's not going to be qualified immunity, but it's something very much like qualified immunity, that if they are acting in their official capacity as a government employee, then they have some sort of immunity as an employee. And if they go outside of the scope of their employment, which is not the qualified immunity standard, but rather this other standard, if they go outside of the scope of their employment, then maybe they can be reached personally and be liable for their behavior. All right, everybody, that is our show. I am Leonard French, your favorite copyright attorney. I'm off to Glasgow, so thank you for your support as we move Kaylee to Glasgow. We're going to be doing a vlog of some kind. Thank you to our supporters. Without your support, this channel would not be possible. At $500 in the months of July and August, Joshua Davis with TandaPay has supported our channel, and we'll be making a video about his TandaPay service, so that hopefully we can help him launch that service into a larger effort. Thank you to the $50 plus supporters: John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Negrey, blackleaf, Spirit Bear, Daniel Perez, Snorre Wisotzky, NotMike, Joe Tyson, and King Macro. Thank you very much for your support at the $50 level. And thank you to the $5 plus supporters who are also scrolling on the LED panel behind me, along with the other rewards as well. Have a good one. I'm Leonard French, your favorite copyright attorney. With me in the virtual studio today has been Brandon and Kaylee and Technical. Thank you very much to everyone. Have a great day, a great week, and I'll see you in the videos that drop. Love you all. Bye.
Iron Brew Energy must be 16 or older to buy. Okay, so we are going to vacuum bag the hamster.
The famous hamster you see in the background of my videos.
The creepy hamster from the background of the videos.
The creepy hamster, so yeah. I guess I hope it fits in the small one. I got other
You'll be able to stuff them in there before vacuuming him, yeah. Just be gentle so you don't rip the bag or those edges. I would stuff, yeah, with
just
your,
like me,
with your fingers, yeah.
Not with how you don't deny it, so.
I don't deny it. You're thick. I like your curves.
Sure.
Is it all sealed? Yeah, look at that. All right.
Hello, guy.
Oh, that happens quick.
Yeah. Look at his face.
Yeah, you have to squeeze them a little bit manually to get it all down. Nice. Nice. That's a pretty good seal for that.
Yeah. There we go. My hamster.
All right.
The creepy hamster.